Welcome back. My name is Ashley Molson, and I'm a New Jersey real estate attorney, and I'm here to help you navigate the New Jersey real estate transaction process. Today, we're going to talk about closing with use and occupancy agreements. And we're going to talk about this from the perspective of being a seller and using this very important tool that is actually super helpful when you need a little bit of time to get yourself out of a home or to carry the gap of time between selling a home and buying a home. All right, so let's just break it down. Use and occupancy agreement. So this is an agreement between two parties, a buyer and a seller, and the seller is saying, I plan to stay in my property that I'm selling to you, buyer, after we close for X amount of time. And the reason why it's called a use and occupancy agreement is because the parties would like to make it very clear to one another that they are not entering into a lease agreement. They are not entering into a landlord and tenant relationship. But in another video, we're going to talk about this little wrinkle that can complicate that. But if everything goes well, there's really no harm, no foul with just calling it what it's usually called, which is a use and occupancy agreement. Now, when is this typically negotiated? Use and occupancy agreements are most often negotiated at the beginning of a real estate transaction. It's really nice when both parties know that the seller is going to stay in the property after closing. I mean, come on. Would you want to be a week before closing and be told that the seller can't leave and that when you close as a buyer, you can't move in? So typically, the goal is to negotiate these things up front and have the terms all laid out and agreed upon early on before you go under contract, so you can make sure that you can just go to closing and have all of the details already wrapped up under your belt, and the whole process will be so much smoother. Now, it is sometimes used as an emergency tool if something comes up where the seller can't get out and it wasn't expected. And sometimes there's some opportunity for the parties to negotiate. So it's not always negotiated in the beginning. The best thing is when all the parties know upfront, when you know you need it, you negotiate it early on, and you just get everything set in stone upfront. So next, we're going to talk about the components of a use and occupancy agreement. The use and occupancy agreement will state, who the parties are, who has the right to stay in the home, and who's giving the right to stay in the home. Additionally, there's usually some sort of charge associated with the seller being able to stay in the property. The customary charge is for the seller to pay a daily or per diem, it's per day rate, of the buyer's principal, interest, taxes, and insurance. This is if they have a mortgage payment. If the buyer is paying cash, things get a little more fluid and negotiable. But when it comes to a buyer who has a mortgage, typically what they're looking to do is to be made whole. They don't want to close on a property, pay for it, and not be able to live there. So as a seller, if you are negotiating a use and occupancy, unless by some, luck, you have a buyer who's offering the U&O, which is short for use and occupancy, for free, you typically have to expect to pay the buyer's PITI, is what we call it: principal, interest, taxes, and insurance. Next, the agreement will have an escrow provision, and the escrow provision will be for some money to be held back, kind of like a security deposit. And it's held back from the seller's funds. And this is to make sure that one, the seller gets out on time, and two, that if there's any incidentals or damage that the seller caused, the buyer can't really do what's called a final walkthrough on the closing day because the seller still lives there. So the buyer will do their final walkthrough after they already own the home. So there needs to be something held back in escrow for incidentals and damages and things like that. Now, another component is it being very clear as to when the seller needs to leave. So having a agreement that the seller will agree to leave at some random date not disclosed is not the way you want to set up your use and occupancy agreement. You definitely want to have a clear date, a clear time that the seller needs to be out. Typical things are like 5 p.m. on a certain day, or the seller gets the whole day until like 11:59 p.m. And then the next following day, starting at midnight, the buyer should have access to the property. So it's got to be very clear. And now, also, if the seller's not out by a certain date, there's a penalty daily rate associated. This is the incentive that drives the seller to actually move. And it's a big risk for a buyer to take on buying a property that the seller doesn't move out of yet. And so there needs to be some incentive to get the seller out. And so, I mean, most often sellers are fully intending on leaving. But just in case, you will take your per diem, the regular one that we talked about earlier, and magnify that maybe 1.5 times, 2 times. It gets negotiated between the attorneys here in New Jersey as to what that daily rate is. That's the penalty, and it can be very significant. And then after that, the next term is how all of this is paid. So typically, the buyer would like to get some sort of funds up front for the per diem if it's pretty clear that the sellers know, okay, we're going to be staying in the property for 5 days and we will pay you at closing for that. If the seller's like, I need 30 days, but I don't know if I need all of the 30 days, then typically the money will be held in escrow next to the escrow for the incidentals. It'll be 2 different escrows. So that can be negotiated as well. All right. And then next, the parties really want to make sure that the insurance coverage gets taken care of. So for the buyer, they are going to be taking out insurance as a policy on the property when they purchase it. So that insurance is called hazard insurance, and the seller, their insurance policy will no longer be in effect because they will have sold the home. So they can take out what's called a renter's policy for their personal belongings. So when you look at both parties together, you kind of have like full coverage of all the things. Seller, their personal property gets covered, and then the buyer has the coverage on the structure and the property itself. And if something happens, then the document will dictate how that will get negotiated. And lastly, there will be a provision that discusses pretty much what use of the property looks like. So it may be very specific depending on the parties' relationship and what they negotiate. Other times you'll see the document covering, like, if something gets damaged, like if a water heater breaks, then the buyer's responsible for it. It's their house now. The seller doesn't just take on the responsibility for the water heater breaking if they didn't break it themselves. The goal is to have a provision that covers the bases so that there's clarity and the parties have expectations managed and they know, okay, I'm taking on this risk, or this risk is not mine, it's the other parties. Those are the main aspects of a use and occupancy agreement. It's usually maybe 2 pages, 3, 4 pages maximum long, ideally signed early on in the process before you go under contract. If you feel that you need time to stay in your property post-closing because you need some time to move, you have another place lined up, but maybe you're buying it the same day that you're selling the house, you may want to negotiate a short-term use and occupancy agreement. But this can't be abused. Typically, buyers are expecting that they can do a final walkthrough on closing day and that the sellers will be out of the home. So this is something that is used as a tool when it's really absolutely needed, and it can come at an additional cost in terms of legal services. And again, that cost you're paying the buyer for the time to stay in the home. And it might be more expensive than putting your stuff in storage and staying with family or even an Airbnb or what have you. So just talk to your attorney upfront, talk to your realtor, and make the best decision for you and your family based on their guidance. But always useful and helpful to know what is out there as an option. I hope this was helpful, and a reminder, like, subscribe, and comment, and looking forward to getting another video your way. My name is Ashley Molson, and I am a New Jersey real estate attorney helping you navigate the New Jersey real estate transaction process.